Hey yo, folks! Welcome to the show. This is a completely new case that has been dragging on since 2018 in Fulton County, Georgia. It is a Fulton County Jail story. It is Antonio May on September 11, 2018, was picked up for a misdemeanor, put in jail, and he never left alive. So this case has been going on since 2018. So I'm going to read from 2018. Then we are going to talk a bit about that. Then we are talking about, because this got in front of Judge McBurney in 2021. And then in 2023, something happened. And now in 2026, it finally came to resolution. But I'm going to keep you a little bit in suspense here. I'm just saying, once we're done here with this case, you're going to be so angry. You're going to be so angry. But let's get to (2018). Dun, dun, dun. Family wants action after man dies in the Fulton County Jail. Published September 25th, 2018. So this is 2 weeks after it happened. This here is Antonio May. So let's read this story. A Metro Atlanta family is accusing jail guards of redrum after their loved one died at the Fulton County Jail. Atlanta police arrested 32-year-old Antonio May on September 11th for criminal trespassing, which is a misdemeanor. They took him first to Grady Memorial Hospital, where he was medically cleared, then on to the jail. His lawyers said there have been 3 different versions of what happened next. The accounts came from an eyewitness in the jail, the Georgia Bureau of Investigation, who was called in to investigate, and the Fulton County Medical Examiner's Office. Most agree May was in his cell, naked, when he asked for water and kept beating on the door. Quote, he's in the cell. They approached him because he had no clothes on. They wanted to strap him down in a restraining chair in a cell. Now, how does that sound? It was 6 guards to this small man, according to the medical examiner's report, explained attorney Michael Harper. Harper, attorney Teddy Reese, family members, and supporters all gathered outside the jail demanding justice for May. The attorney said May was not bringing any harm to anyone when he was in his cell. The Fulton County Medical Examiner's report stated May was self-pleasuring in his cell, and the guard asked him to stop, but he refused. Even if he was doing this with no clothes on, he's not bothering anybody, Harper exclaimed. The ME report also stated May tested positive for ecstasy. According to the report, 6 guards assembled at May's cell to put him in a transport chair. That is when a stun gun was used twice, as well as pepper spray, then put in the shower for decontamination. He was restrained at that point into that chair, locked into the chair, put into his shower area where they had to decontaminate him to wash off the pepper spray that was in his face. He came out of that area, went unresponsive, and died. The preliminary autopsy was inconclusive. This family wanted the officers involved suspended and Fulton County District Attorney Paul Howard to investigate. Harper said the taser should not have been used because of the substance that was in his body. The guidelines from the taser company says if a person is on drugs or have a prior medical condition, you don't tase them. People always say, when it's black on black, we never say anything. This event occurred with all African-American officers and an African-American male. It's not about race. It's about basic fairness. It is about basic justice, Attorney Ted Reese exclaimed. Fulton County Jail officials said they called in the GBI to investigate immediately and did not care to comment further out of respect for their family. The final autopsy was still pending as of Tuesday afternoon, back in 2018, and should determine the cause of death. And then, during the prior administration in Fulton County, nothing happened. Nothing. Until 2021. I have to say, this is one of the first cases on her docket. I have to give credit for this. Yeah, this is... Fanny, I don't like giving credit, but the prior administration did nothing. At least she did something. Fannie Willis and the new administration in 2021 took this to Judge McBurney. They went to a grand jury with the information they had, and all 6 guards were indicted for murder with the information they had. In 2021, in Judge McBurney's court, Judge McBurney threw it out because, according to his determination, jail guards or jailors are equal to peace officers, and as such, they have a higher immunity. That was, of course, it took a while. So I believe that he put that into effect in 2022. Then something else happened. Let's show it. Dun, dun, dun. There. Supreme Court reverses decision to throw out charges for Fulton County jailors in inmate's death. This was October 11th, 2023. The Georgia Supreme Court has overturned a lower judge's decision to quash an indictment of 6 Fulton County jailors for the death of an inmate in 2018. Aaron Cook, Guido de la Cruz, Omar Jackson, Yasser Roach, Kenesha Strouder, and William Whitaker were facing murder charges for the death of Antonio May. According to the indictment, Atlanta police arrested a 32-year-old Macon resident in 2018 on misdemeanor trespassing. Authorities said he had been throwing rocks at the American Cancer Society building. According to the report, Yeah, this we already have. After investigation, the Fulton County District Attorney charged the 3 current and 3 former with felony murder, aggravated assault, battery, and violation of their oath of office. However, Fulton County Superior Court Judge Robert McBurney determined that the 6 were designated as peace officers who were vested with a duty to maintain public order, i.e. keep the peace, and entitled to certain legal protections connected to indictments. According to Georgia's code, current and former peace officers need to be given a copy of the proposed bill of indictment or special presentment and be notified in writing before they are indicted, which Fulton County did not do. So, a technicality. They got off on a technicality. By ruling that the 6 were peace officers, McBurney quashed the indictment, though he said that prosecutors could get a new indictment if they followed the correct procedures. The Supreme Court unanimously disagreed with McBurney, saying that, quote, while it is true that the defendant's work may have benefited the public peace, a tangential benefit to the public peace is not synonymous with a duty to maintain the peace within the community as a whole. The court said that the defendant's primary duty was limited in comparison to the traditional definition of a peace officer, declaring McBurney's decision an error, and reversed his ruling to throw out the indictment. Fannie Willis wrote, we are pleased the Georgia Supreme Court recognized that the special privilege for peace officers to appear before a grand jury is limited and does not apply to the defendants in this case. We will now move forward to trial to seek justice for Antonio May and his family. This, I actually found out, was a de novo ruling. So this is new case law in Georgia that a jailor or a prison guard, there's many names for prison guard, but in Georgia they use the word jailor. Now it is case law and precedent in Georgia that jailors do not have the same protection as a peace officer, which is quite interesting because this is as recent as 2023. This is as recent as 2023. So all the machinery started working again. They had to, back in front of Judge McBurney. Now, this took a while. This took a good while. But what happened was, on April 20th, 2026, 2.5 years later, they were back in court for an immunity hearing. And this is what we are going to listen to now. Dun, dun, dun. I'll put myself in, no, not in that corner. Up here. There's no lawyers up here. Judge McBurney, everything, when he is in court, he live streams. So you always have this image to go by. If it's a bigger case, you can see it on Law and Crime and stuff like that. But this was not regarded as a bigger case, mainly because it took from 2018, it took 8 years, almost 8 years, 7.5 to get here. So the interest blew over. If this, because lately, the past 1.5, 2 years, there's been several cases with prison guards in altercations with inmates, resulting in bodily injury and even death. All right, so let's listen to this immunity hearing. Let's see, let's get the... Oh, hold on. Boost the sound a bit. I don't normally do that. All right.
Good morning. Yes, I can.
Great. We're going to get started. This is 21 SC 180150, Cook et al., a 6-defendant case for which we have gathered to hear several immunity motions. Let's figure out who all is here and talk about how we want to proceed this morning, given that we are in a courtroom that's kind of built for 2 or 3 defendants, but we've got 6 defendants. If I could have the appearances for the state first.
Good morning, Your Honor. Tanya Boykin from the state.
Hello, Ms. Boykin.
Good morning, Your Honor. And we do have some announcements on some actions that we'd like to take on some of the cases at the appropriate time.
Okay. Let's figure out who all is here, and then I'll start with your announcements. Thank you. Mr. Cook, are you here? Hey, Mr. Cook. Your lawyer, Mr. Majeski, had a conflict. Has he talked to you about his whereabouts?
Yes, sir. Mr. Issa is on the way up.
Oh, Mr. Issa's going to be here.
Yes, sir.
Okay. Well, we'll hold for him. Mr. Dela Cruz?
He's here. Well, he's downstairs in the security.
Okay. And his lawyer's parking, so they'll be here soon. Mr. Jackson? Good morning, Mr. Aurora. Good morning. Thanks for being here. Ms. Strouder? Good morning.
Dr. Robin, Your Honor.
Mr. Grubman, thank you. Mr. Whitaker, there he is. There's Mr. Pines. Good morning, everyone. And Mr. Roach is here, and so is Ms. Clark Palmer.
Yes, good morning.
Good morning. What are you doing here?
Judge, I'm representing a witness that's been subpoenaed.
Okay. Well, I'm glad you're here. All right.
And just, we're intending to take the Fifth Amendment to any relevant questions that are asked.
Okay. We'll cross that bridge should that bridge present itself to us. Thanks. Ms. Boykin, you're up.
Yes, Your Honor. The state moves to non-cross the charges against defendants Cruz, Jackson, Roach, Strouder, and Whitaker. Your Honor, we do intend to still pursue the charges against Mr. Cook, and in speaking with his attorney, Mr. Majeski, we expect him to enter a plea. And he also informed me that Mr. Issa will come and report to court on Mr. Cook's behalf this morning.
Yeah. 7.5 years later, a man is killed in his cell. They get a Supreme Court decision. It is okay. No, they don't have immunity. They have a grand jury indictment of felony murder on all 6 of them. And the state drops the charges. They do a non-pros on 5 of them. And they worked out a deal on the 6th, Mr. Cook. A man is dead by the hands of 6 jailors. And 5 of them scot-free. Scot-fucking-free. Despite Fani Willis in 2023 said they're moving forward. So the credit I gave her a few minutes ago, I'll take it back. I'll take it back.
And Mr. Issa would handle the plea, or the plea would be at a later date when Mr. Majeski could be here?
That is my understanding that Mr. Easter will handle the case today. Your Honor, since taking over the case, we conducted a review of the case, and it's a very voluminous file, a very old case, went up on appeal, and so there was a lot to review in addition to the filings by defense counsel. And so with respect to the defendants that we intend to null cross, we determined that we could not prove our case beyond a reasonable doubt. All the probable cause existed during the grand jury.
Okay. And this decision that you've made is something that you have discussed with Mr. May's family.
Correct.
This isn't news to them at this very moment.
It is not, Your Honor.
Okay.
We had a lengthy Zoom with them on Friday, myself, Edie Abati, my investigator and our victim advocate, and explained our actions, also the plea offer that we were going to make to Mr. Cook. And it's my understanding that they do not plan to attend in person, but may get on the Zoom link. And so we're reaching out to our victim advocate to see what the family wants to do, but they're well aware of
Okay.
the proceedings in our decision.
Good. I appreciate the thoroughness. And I will say, having read only briefs, we didn't hear evidence yet, but reading Mr. Grubman's brief and Ms. Clark Palmer's brief, it did sound like for at least some of the defendants, there were going to be some evidentiary challenges, recognizing that this was only one perspective of what the evidence showed. And there was the larger issue that I know Mr. Pines has flagged a number of times of causation of death in the end, independent of whether any of these detention officers or deputies exceeded the bounds of their authority in the way they treated Mr. May. So it was complicated. I appreciate that you and Mr. Abati have thought about it hard and reviewed it and aren't going to be.
You know what else happened between 2023, 2024? Do you know what else they did in Fulton County? The YSL RICO, where they pursued everything with jack shit evidence. But here, where a man is dead by the hands of 6 jailors who did not follow protocol, they just roll over. I would assume it is because the evidentiary issues are the eyewitness is another inmate. The witnesses who has credibility are other jailors. Oh, look at that French cycle. Bonsoir. Or for you a beer or make a stream, we can share it with you. Thank you. Raid! I'm raided. I didn't see it. Is it Squid's Pro Quo raid? Ah, there. Hey, thank you. Yes, so they have built this case. They took it all the way up to the Georgia Supreme Court to continue the case. They won in the Georgia Supreme Court, changed precedent, changed case law, new case law in place. Jailers do not have the same immunity as peace officers do. Whew. and then they just roll over. Blames evidentiary challenges. Well, those challenges meant jack shit in the YSL RICO trial. They just went ahead anyways. And here, there was actual evidence of protocols not followed, excessive force resulting in a man's death. There were cameras in that jail. But no.
Bringing the family through a process that might end in a way that's frustrating for them even further down the road than the many years we are down the road. So thank you for that review. So to go back in the order of Mr. Dela Cruz, I'm gonna wait till, he's not here.
Oh yeah, did you see how she didn't mention how they reacted to this?
Yeah, I'm gonna wait till his lawyer gets here. Mr. Jackson. The state has announced that it's dismissing the charges against you in this case. Do you understand that? Mr. Aurora, anything you want to add to the record? Do you oppose the state's motion?
No, Your Honor. Do we need to file the expungement or is that something that's done automatic?
Nothing is automatic.
Okay.
All right.
I'll take care of it.
While I have, you can take a seat, Mr. Jackson. Mr. LaChapelle, so we're on the record, but off topic. My understanding was that the family purchased a different house for him, that he won't be with the grandparents, but there's something in Cherokee County.
But if I can approach after we're done with
Okay.
this, I need to explain to you.
Okay. As I just want to clear that up, the probation was reaching out, but in a good way. So if you don't mind waiting till we get through this, but we'll discuss it before the plea. All right. Ms. Strouder, the state is dismissing the charges against you. Do you understand that? Mr. Grubman, any objection to that?
No, Your Honor, and we'll also be filing a motion to seal the record shortly.
Okay, I'll look for that. And whatever you file, if you would email a courtesy copy to Ms. Nelson, that way it'll hit my radar sooner. Okay? All right, thank you. Mr. Whitaker, the state is dismissing the charges against you. Do you understand that? Mr. Pines, any objection to that?
No objection.
Anything else you want to get on the record?
I do have two orders prepared. They would be sealing orders. Obviously, the court knows once the case is dismissed, it'll be restricted automatically pursuant to law. But in order to seal the file, we did need an order. I have one for the 21 SC 180150 and one for 21 SC 179686. With those
They plan to seal all the evidence. So that nobody will ever know what evidence they actually had.
was the first case that was null process.
The predecessor.
Correct.
Yeah.
I did prepare sealing orders
Great.
for the court's consideration / signature. I was just asking they not be filed until I get copies of the null process, which takes a minute in the clerk's office.
Okay. You can get those to Deputy Gordon. He'll get them to me, and I'll look at those later today. And Mr. Roach. Good morning again, sir. You understand the state is dismissing the charges against you. Ms. Clark Palmer, any objection to that or anything you want to add procedurally?
Objection. I will email Ms. Nelson proposed sealing orders. And to the extent that the witness, I had subpoenaed 2 witnesses. Major Sadiq.
I'm here for Derek Page.
Oh, that's not my witness. Okay, never mind.
Okay.
So I had subpoenaed 2 witnesses and I'll release to the extent they're here for my subpoena. It's Major Sadiq and
Is Major Sadiq here? There she is. How are you? See, we got you out of the jail after all. I appreciate you being here and complying with the subpoena.
She may be under the state's subpoena as well. No? Okay, all right, so she is released, and then, I had also sent a subpoena to one other witness. I'll find it and I'll release that witness too.
Okay. All right. Thank you, Mr. Roach.
Yes, you're released, sir. Thank you.
Good morning, Mr. King.
Morning, Judge. How are you? I apologize for being a couple minutes late. I apologize.
Traffic's complicated with all those red lanes out there now. Who knows what's going on? Mr. Cook is here. No, I mean, Mr. Delacruz. Mr. Delacruz wasn't, he is here. Great. He walked in with you, I guess. While you two were out of the room, Ms. Boykin announced that the state is null processing or dismissing the charges against Mr. Delacruz. Hopefully not news to you, but Mr. Delacruz, I want you to understand that the state, after a careful re-review of the evidence and considering it not so much as to whether you could be charged, but whether they could meet their burden at trial, the state is dismissing the charges against you. Do you understand that? Okay. Mr. King, do you have any objection to the state's motion?
No, we don't.
Okay. Anything else procedurally from you on behalf of Mr. Delacruz?
No.
All right. That's it. Thank you.
Thank you.
So, Mr. Cook, we are waiting on Mr. Issa to get here. And you said he's somewhere in the building or he's approaching the building? He's in the parking. All right. Then we'll sit tight on that. Ms. Boykin, anything else while we're waiting?
Sorry,
That's okay.
nothing further from the state.
All right. Then we will pause until Mr. Issa gets here. So you know, Mr. Cook, when Mr. Issa gets here, I'm gonna have you come on up front. You can stay where you are till he gets here, but then you'll be up at the podium, okay? All right. Thank you, everyone. Mr. Aurora?
Let's see here if they come back. No, they're taking other cases.
To your,
Oh, there.
we'll get all that on the record. Excuse me, because Ms. Rivers is remote, I need whichever ADA is going to handle the plea to come up to the witness stand and get comfortable there. And then Mr. Issa, you and Mr. Cook should come on up to the podium. Mr. Cook will be to your left.
Do we need to sign copies, signing that?
We do that electronically now. So I'll cover that. If you could bend the microphone down so Ms. Rivers can hear you.
All right, Mr. Cook,
Hold on one sec. We'll get started. There we go. All right. You get Mr. Cook on the screen. Thanks. Mr. Cook is a little taller than our usual defendant. All right. So we're going to get on the record again in 21 SC 180150. We are handling the matter of State versus Cook. The other 5 defendants have had their case addressed this morning. Mr. Cook is here in court with Mr. Issa. Mr. Cook, your attorney of record is Mr. Majeski, who is an associate and colleague of Mr. Issa. So same law firm, same practice, but you may have worked more closely with Mr. Majeski. Mr. Issa tells me that you're prepared to enter a plea, and I just want to get on the record that you've got no concerns or issues with the fact that Mr. Issa will be assisting you during this conversation rather than Mr. Majeski.
No, sir, I don't have any
You're okay with that?
Yes, sir.
Great. I need you to speak up a little bit when you're answering so that Ms. Rivers can hear you, okay?
Yes, sir.
Great. Ms. Boykin is handling things for the state, and in just a moment, Ms. Boykin is going to put you under oath. Once you're under oath, she will ask you questions about your rights, about this case, etc. You need to answer those questions truthfully and completely. You also need to let your lawyer or me know if at any point you have questions of your own. Will you do that?
Yes, sir.
Great. Ms. Boykin.
Mr. Cook, please raise your right hand.
It's good. You're good.
Do you swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your true, correct, and legal name.
Aaron Cook.
Are you known by any other name or an alias?
No, ma'am.
Can you spell your first name?
ARRON.
Mr. Cook, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you?
I'm 34, ma'am.
And how far have you gone in school?
High school.
Did you finish high school?
That's correct. Yes, sir.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Did you go over the accusation and, the indictment and forms with your attorney?
So the only document we're talking about right now is the charging document, what you were charged with. You're familiar with what you're charged with?
Yes.
Okay.
In this indictment, do you understand you've been charged with felony murder, aggravated assault, battery, violation of oath by a public officer, 2 counts of that?
Yes.
Do you understand that you have the right to either plead guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent, you will receive a jury trial?
Yes.
Your Honor, does the court require a waiver of rights form?
No.
Okay. Have you had enough time to speak with your attorney, Mr. Majeski, and Mr. Issa about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this case with your attorneys?
No, ma'am.
Are you satisfied with the services of Mr. Issa and Mr. Majeski?
Yes, ma'am.
Mr. Issa, do you waive formal reading of the indictment?
We do. Also, I notified the client that if he had any concerns or questions during this process of the plea, he could always tell the court and tell me he needs a moment. We'd be able to step aside and answer those questions.
Mr. Cook, do you waive any and all defects in the indictment, including with respect to your client's name?
I do.
Mr. Cook, has your attorney advised you of the minimum and maximum sentence for each charge?
In preparation for this plea we have, and I know that John has spoken with him over the phone extensively from Friday until this morning about this plea.
Yes.
If you want to repose a question, you're welcome to as well.
Mr. Cook, do you understand that for the plea today, the maximum that you're facing on aggravated assault is, well, the range for aggravated assault is 1 to 20 years, and for violation of oath by a public officer, 1 to 5 years?
Yes, ma'am.
Okay, and did you discuss that with your attorney, Mr. Majeski?
Yes, ma'am.
Do you understand that this is a negotiated plea, which means that the joint recommendation of the state and defense to the court will be a sentence of 5 years probation?
Yes, ma'am.
Also, the conditions of probation would be that you have no further employment in law enforcement, security, detention, or correction facilities.
Yes, ma'am.
Do you understand, however, that the court does not have to accept that recommendation? The court can sentence you to the maximum on each charge and can run those sentences consecutively, one after another.
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea, you have the right to withdraw your plea of guilty?
Can you repeat that?
Do you understand that if the court decides to order a sentence that differs from this negotiated plea, you have the right to withdraw your guilty plea?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or special conditions of probation without being subject to revocation of the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess nor use a firearm while on probation?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am, I am.
So do you understand that there may be other adverse, unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, a guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
And do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which will carry a sentence of 1 to 15 years?
Yes, ma'am.
Mr. Cook, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pleaded guilty or nolo contendere to, or have been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, misdemeanor, or felony under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes.
And so do you understand that if you violate the terms of your first offender discharge or commit a new offense while on probation, that status could be revoked? You could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge in this indictment.
Yes, ma'am.
Do you understand that if you successfully complete your probation under the First Offender Act and are discharged, you can honestly say that you have not been convicted of a felony?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes.
And do you understand that that by pleading guilty, you also give up the right to a trial by jury?
Yes.
You also give up the right to remain silent and not incriminate yourself?
Yes.
The right to confront witnesses against you?
Yes.
The right to court-appointed counsel, court-appointed counsel if you cannot afford an attorney or counsel hired by you?
Yes.
The right to the presumption of innocence?
Yes.
The right to testify on your own behalf and to present evidence?
Yes, ma'am.
The right to subpoena witnesses and compel the production of evidence?
Yes.
Do you understand the right to have the charges proved against you beyond a reasonable doubt?
Can you repeat that?
Yes, sir. You give up the right to have the charges proved against you beyond a reasonable doubt.
Yes.
And you also give up the right to appeal if convicted of these charges at trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No.
With respect to indictment 21 SC 180150, sir, how do you plead to the charges of aggravated assault and violation of oath by a public officer?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today's date for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Do you understand that you have until the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes.
Your Honor, a factual basis for the plea, had this case gone to trial, this was an incident that occurred September 11, 2018 at the Fulton County Jail located in Fulton County, Georgia. The victim, Mr. Antonio May, became an inmate at the Fulton County Jail. The previous day, Mr. May got arrested by APD. He had thrown a rock into the building of the American Cancer Society located here in Atlanta and was arrested on some misdemeanor charges.
Allegedly.
Due to Mr. May's behavior and his admitted methamphetamine use, he was taken to Grady Hospital where he was examined.
They only found ecstasy in his system.
stabilized and released into the custody of the Fulton County Jail. When he arrived at the Fulton County Jail, it was about 8 a.m., 8 o'clock hour during the first shift. Encountered some deputies during that shift, but there were no, instances of problems. During the second shift, this defendant, Antonio Cook, along with the other officers who were in the indictment, were working their shifts at the Fulton County Jail. Mr. Cook was a detention officer with the Fulton County Sheriff's Department. During that time, Sergeant Sadiq, who was also on duty at that time, had observed Mr. May and masturbating in his cell. He was completely naked. She had previously given some verbal responses for Mr. May to stop. And when he did not, she placed a privacy screen over his cell, blocking view of Mr. May and from Mr. May to see other people. She then called over Mr. Cook to come over and assist and essentially make Mr. May stop. Again, Your Honor, at this point, Mr. May was in his cell alone. He was completely naked. He did not possess any weapons, and there was the privacy shield. According to the defendant's statements and the statements of the other officers, Mr. May was
According to themselves.
In his cell when the defendant first approached the cell. So when he approached Mr. May's cell, it was locked and he was on the other side, but had already pulled out his taser. And the state's, we believe the evidence would show that upon asking Mr. May to get clothed, him refusing, the defendant asked for his cell to be opened, and then it immediately began tasing Mr. May. The state's position is that in accordance with the law and in accordance with the SOPs at the Sheriff's Department at the time, that there were lesser de-escalation tactics that Mr. Cook could have used. And Your Honor, I'll specifically refer to SOP number 1515, that was back in 2002, but in effect at the time that this incident happened. And particularly subsection C says it is the policy of the jail bureau to ensure the use of force is restricted to instances of justifiable self-defense, protection of others, protection of property, prevention of escapes, and then only as a last resort in a court.
He went in their taser. The guy was harmless. Yeah, uncomfortable for people around, but harmless. And this guy decided, I'm going to teach him a lesson. And went for it. Taser. Mace. Restricted to his chair. Could not defend himself whatsoever. Had other injuries. In my opinion, the 6 of them beat the ever-living fuck out of that poor guy. And then dragged him to the shower to to wash it off. Ice cold water. And Mr. May's heart failed. There were none. According to the autopsy, he had no underlying heart condition. So the claim they only tased him twice is them self-reporting. We don't know. We don't know. Mr. May had a history of mental illness. He had a history of drug use. They took him in. He could have spent the night in jail, in front of the magistrate in the morning. Could have ordered, off you go to the mental. Where's all the camera footage? They were inside the cell. There are no cameras in Fulton County Jail. There are no cameras inside the jail. They have a centralized system with cameras outside pointing to cells. But there were 6 of them blocking the view, probably. And now the case is sealed. I couldn't get it if I wanted to. So 6 of them beat the ever-living shit out of him, tased him at least 2 times, and I'm saying that very, very liberally, maced him while he was in the chair, bound to the fucking chair. And 5 of them walked. And this motherfucker gets probation. 5 years probation. And now with that probation comes, he cannot join law enforcement. A lifetime ban. Problem. First time offender. If he does nothing, if he doesn't violate his probation in a few years, he can ask to have it expunged. And if granted, it goes away completely. As if he had done nothing at all. And with expungement, that condition disappears as well. A man is dead, and his killers walk.
Accordance with the appropriate statutory authority, physical force should never be used as a punishment. Deputies and detention officers will only use the type and amount of force necessary to effect lawful objectives. In cases where a threat of bodily harm is imminent, authorization is required. If possible, all reasonable alternatives will be used before applying physical force, such as persuasion, verbal commands, show of force through deputy detention officers' presence.
There was 6 of them. They could have just grabbed onto an arm, a leg each. But they decided, no. We're going to beat him into a fucking pulp and tase him and mace him.
Resistance in the form of psychological intimidation and verbal compliance is met with verbal commands and deputy demeanor to include stance and distancing, which the deputy exhibits. Resistance in the form of passive or defensive resistance is met with soft techniques when level 1 control is not effective. Your Honor, in addition, there's another SOP 1400-8 that talks about the use of tasers. It says ECDs will be restricted to instances of justifiable self-defense, protection of others, protection of property, and prevention of escapes. And again, then only as a last resort in accordance with the appropriate statutory authority. In no event will ECDs be used as punishment. Your Honor, the state's position is that Mr. Cook could have used de-escalation tactics, again, including a show of force, other soft techniques, and that the use of the taser actually started the aggression, and he was the initial aggressor in this case. And because he did not use those techniques, this caused Mr. May to act in the way that he behaved, causing other deputies, up to about 7 or 8 other deputies, to have to tend to restrain him, and deal with the situation involving Mr. May. During the course of this incident, Mr. May was tased, drive stunned by other officers who went inside of the cell. He was restrained, and that did cause some.
He went in, provoking a reaction, tased him, and when Mr. may or may not have said something, you motherfucker, what, and then they all went in for him. Tasers and mace. They were all there because they wanted to beat Mr. May into a pulp. He was the, oh, you can't do that, Mr. May. And now he's dead. Because of these fuckers. And they walk. Because the other witnesses are inmates. Had he lived, who knows, they might. The only reason we know about this is because he died. Had he lived, they might as well have said, hey, he threw himself against the walls. Who knows? Now, in my opinion, yeah, first time offender, first time caught. I would say first, you don't start off like this. This, in my opinion, is something that happens a lot in jails. This is probably not the first time Mr. Cook and the other jailors did this to somebody because they wanted to. And they killed him and they walk.
Bruises and contusions to his body. There's also evidence that Mr. May was struggling with the officers during that time as well. He was sprayed with OC spray. They put a spit mask on him, put him in a restraint chair, and he was taken to the shower area for decontainment. Shortly after being brought out of that area, and this part is captured on video, Mr. May subsequently loses consciousness, and you see the officers attending to him, trying to revive him, but he eventually passed away. In reviewing this case, as the court acknowledged earlier today, while Mr. May died of a cardiac episode, the medical examiner could not determine the manner of death, and so the manner of death was undetermined.
To nobody's fucking surprise, the medical examiner writes down undetermined. He was beaten to a fucking pulp, maced and tased. How is that to be undetermined? His heart gave up after a serious assaults. A series of assaults going on for minutes. Sometimes the injuries are too severe that the heart gives up. But the medical examiner conveniently writes undetermined.
Your Honor, the state's recommendation is 5 years probation on aggravated assault and violation of oath to run concurrent. Again, defendant will be on probation, no employment in law enforcement, security, detention, or corrections facilities. We have no objection to first offender. As I mentioned earlier, Our office met with the family, the aunt and uncle of Mr. May on Friday via Zoom. Mr. Abate, our victim advocate, Miss Alana Rolak, and my deputy chief investigator, Mr. Saul Alter. And we explained extensively to the family our review of the case, the legal hurdles that we had approved in the case, and specifically our actions to non-prosecute charges against the defendants that we did and pursue the charges on Mr. Cook. And we also explained that we will be asking for a probated sentence today and those conditions of probation. So our victim advocate is here. The family is watching on Zoom and YouTube. And I think she would like to read a victim advocate statement, victim impact statement at the appropriate time.
Sure. Well, I think we're at about that time. Ms. Rolak, good morning. I don't see anyone on the Zoom, so they may be watching through the live feed. But more importantly, it sounds like they've asked you to share a statement on their behalf, and I'd be happy to hear that. I just need you to be near a microphone, so if you don't mind taking a seat right there at the state's table. And is the microphone green light on?
The red came off with the green.
The green light on.
Oh, so it's just, if there's no light on, that means it's working? Okay. When you are ready.
Good morning, Judge. Ilona Rolak on behalf of the May family. This statement is from Stephanie May, Stephanie, May, M-A-Y. Dear Judge McBurney, I am writing to you with a heavy heart and an urgent plea for justice regarding the death of my nephew, Antonio May. While he was incarcerated at the Fulton County Jail in 2018, it is our understanding that Officer Aaron Cook was the first to enter Antonio's cell during the incident that led to his death. We have been informed that Antonio was subjected to extremely excessive force while he was handcuffed and restrained in a chair. No human being deserves to be treated in such a manner, especially while already in custody and unable to defend themselves. Antonio was more than just a name in a report. He was a father, a son, and a brother. He was loved deeply by his children, his father, his only living parent, and his entire family. His life mattered, and his loss has left a permanent void in all of us. His children in particular continue to suffer from the absence of their father, and they deserve answers and accountability. Since 2018, our family has waited in pain and confusion, feeling as though Antonio's case has been overlooked and forgotten. It is devastating to believe that something so serious could only have a probation sentence. We do not agree with that outcome. We respectfully ask that you consider our family when you sentence Mr. Cook. We are not only seeking accountability, but also acknowledgement of the wrongdoing that took Antonio from us. We ask you to consider the lasting impact that this has had on his children, his father, and all who loved him. Antonio did not deserve what happened to him, and his life should not be dismissed as insignificant. Thank you for your time and attention to this matter. We're holding on to hope that justice will finally be granted. Thank you, Judge.
Thank you, Ms. Rolak, and Ms. May, if you are following the proceedings this morning. Appreciate that. Mr. Issa, on behalf of Mr. Cook.
Yes, Judge. Hearing this case started in 2018 and Mr. Cook's lack of any sort of criminal history, we're asking the court, in accordance with the plea agreement that's been made, to consider a bid date of 1 year. This is not new to the state. We mentioned this to them over the weekend as well. and ask this court to consider that since 2018, this has been pending, and much less the indictment since 2021, this case has been before this court, if not earlier. Echoing that he's got no criminal history whatsoever and that he's had no issues or infractions since, we think that his time in supervision and his time in this case pending on his shoulders should be considered by this court. And of course, we know that first offender plea on this type of case is unique. We don't always see these kinds of indictments reduced to this type of plea agreement. Nonetheless, we know that Mr. Cook will not be before this court again, as he hasn't been before the court before, and certainly has only come to court upon the court's request for these types of hearings. Mr. Cook and Mr. Majeski in my office were prepared for a hearing this morning, and the court was prepared for a hearing this morning as well. Being that this resolution is one that we're opting into and asking the court to consider, we think it's the right result. And for Mr. Cook to move forward for him and his family, and so that he can move on from underneath this indictment and, continue to show the court that he's ready to move forward and not have any more involvement with this case or the court at all.
Oh, poor Mr. Cook. Poor Mr. Cook. This has been so hard on him. He just killed a guy. I mean, show some... Fuck. This isn't justice. This isn't even close to justice. He gets to get home to he's been with his family the past 7.5 fucking years. Well, Mr. May's family buried him 7.5 years ago. And now Mr. Cook gets to walk out of the courtroom. Don't fuck up. And in a few years' time, seek to expunge this. And then it is as if it never happened to Cook. Mr. May is still dead. But Mr. Cook gets to go home.
Mr. Cook, what have you been doing professionally since this indictment? It's been 5 years. You working?
No, sir.
How have you been maintaining? Like, you're dressed, you've been eating. How's that been happening?
My wife, sir.
Okay. What does she do?
She's a surgical technologist.
Okay. Are you hoping to get back to work?
Yes, sir.
Doing what?
Something that pays the bills, sir.
What do you have in mind?
Transportation.
Okay. Have you been thinking about options, knowing that today was coming?
Yes, sir, I am.
Okay. Transportation as in truck driving or Uber driver or race car driver?
Someone on the lines of truck driving and pilot car.
Okay. Do you have kids?
Yes, sir, I do.
How many kids?
4.
How old are they?
16, 13, and
Younger than 13? Okay. 2 little ones. All right. Tell me.
Before or after you killed Mr. May? Are they younger? Were they born after 2018? You got to go home, impregnate your wife while Mr. May was buried and never got to see his kids again? Is that why you chose to not say it? Because it would show that you had suffered nothing. Nothing. You haven't worked for 7 years, or since the indictment, for 5 years. You just sat at home, feeling sorry for yourself. Boo fucking who?
What you're feeling right now?
Just want to move forward.
Really? No apology to the family? None?
And just want to get back on the right track, you know.
You don't?
Yes,
Okay.
You didn't even apologize to the family. It's Trinton asked, did you cooperate against the other jailers? No! The other jailers. The prosecution did a null pros, meaning they walked free. No repercussions whatsoever. They just folded.
All right. Well, Mr. Cook, I find there is a factual basis for your plea. It sounds like it was a chaotic situation that maybe became more chaotic because of a split-second decision you made at the outset.
Oh, Judge McBurney, that was not a split-second decision. That was him with a taser in hand, determined to walk into that cell and hurt Mr. May, leading to his death. And this motherfucker only feels sorry for himself and wants to move forward. You're a murderer, Mr. Cook. You might not be a convicted murderer, but a murderer nonetheless, and you show no remorse, no apology to the family, nothing.
But I very much appreciate the state's careful review of all the things that happened and the way they've decided to work through it today. I also find that your plea is knowing and voluntary. Knowing means you've understood the things Ms. Boykin was asking you about. Do you agree with that?
Yes, sir.
And voluntary means no one's forcing you to enter this plea, but you've decided that it's in your best interest to do so. Is that correct?
Yes, sir.
Your lawyer has asked that I sentence you as a first offender. You qualify for that. You've never been in trouble before. And as he's pointed out, over the many years these charges have been pending, you've managed to continue to stay out of trouble.
He's being at home. He's been leeching off his wife for the past 5 years.
First offender is primarily a benefit. It means that this is not a conviction. You will be what we call a first offender probationer. So you will have a sentence, but not a conviction. So as you are trying to move forward and applying for jobs or going back to school, you don't have to check that box that says felon. You are not a felon now. You won't be when you leave the courtroom, and you will remain not a felon provided you do well on probation. The downside of first offender is that if you end up not moving forward, but backwards or sideways, and you get in trouble for something, not only do you have new charges, but this case could result in a resentencing. And if the new charges involve you being violent with someone, I can tell you that the new sentence would look very different than 5 years probation. And you need to understand that the maximum would be 25 years, 20 for the aggravated assault and 5 for the violation of oath of office. And I don't mean to suggest that you'd suddenly get hit with a 25-year sentence, but you need to know that that's the maximum that's out there as a first offender. If you get your first offender sentence revoked and you're resentenced, that whole range is available depending on what it is that caused that revocation. Do you feel like you understand the benefit and the risk of first offender?
Yes, sir, I do.
Do you want to be sentenced as a first offender?
Yes, sir.
All right, I'll do that. Mr. Issa, can someone in my office electronically sign the indictment on your behalf?
Yes.
Ms. Boykin, can we do that for you?
Yes, Your Honor.
And Mr. Cook, is it all right if we electronically sign your name indicating your first offender plea to counts 2 and 4 of the indictment?
Yes, sir.
And you probably said it, Ms. Boykin, but counts 1, 3, and 5 are being null prossed?
Yes, Your Honor.
All right, we'll make sure that's notated on the indictment as well. So, Mr. Cook, I think the sentence is a reasonable one. I also think it's one that understandably confounds Mr. May's family. There is a nephew, a son, a father who died as a result of what happened in September of 2018. And I can understand how that family links it to the decision you made to go in the cell and do what you did. Another way to have approached that would be let the guy do whatever he's doing in his cell. Leave the privacy shield up, and it's not what anyone wants to watch, but it doesn't require someone your size armed with the taser to go in there to stop it. There was no risk of harm to anyone at all in that setting. But I wasn't there. I don't have your job, and that job is a difficult one where split-second decisions need to be made for your safety and the safety of your colleagues and of other inmates. It is a tragic outcome, and I know the May family has tried to seek justice in federal court, here in state court, and they feel shut out, and I don't want them to continue to feel that way. But I also think that this resolution reflects all of the facts and circumstances that the state confronts. If you had said, no, I want to go to trial, prove that these things happen beyond a reasonable doubt. So I will sentence you on count 2 and count 4 to 5 years probation. I'll run those concurrently. It will be a special condition of your probation that you not seek employment in the field of law enforcement, private security, or as a detention officer. Sounds like you're not heading in that direction anyway. I'm also going to add a condition that you complete 100 hours of community service. You need to do that during the first year of probation. I will set a behavioral incentive date of April 21st of 2028. That means that if over the course of the first 2 years of your probation, you've done what you told me and your wife and your family you want to do, which is to move forward, contribute to the household, earn a living, legitimately, all those things, and you've taken care of your probation responsibilities, probation can come to me and say, this is a model probationer. We're wasting our time supervising him. Can we close this case out? And I will consider that. And if it makes sense, that's exactly what I'll do. Ms. Boykin, anything else on behalf of the state?
No, Your Honor.
Mr. Issa, you should talk with Mr. Cook briefly. The sentence I imposed is marginally more serious than what you advocated for, and he has the right to withdraw his plea because I added that condition of community service. So why don't you two huddle and then let me know if Mr. Cook wants to go forward.
I'll take it.
All right.
The beating in the cell, several minutes. Repeatedly tased.
We accept the court's
Mace
additional condition
while
of
he
100 hours
was
of community
cuffed
service
to
imposed
a
on the
chair.
sentence, Your Honor.
All
The
right.
date you provided is something he votes positively for.
Okay. Mr. Cook, what county do you live in?
Clayton County.
Clayton County? All right. On the Zoom call is Ms. Simpson. She is with probation. She's going to give you reporting instructions. And Mr. Issa, if you don't mind writing them down, if you've got a piece of paper you can give to Mr. Cook. I don't remember where the Clayton County reporting location is, but Ms. Simpson's going to tell you where to be and when to be. Don't miss that first appointment. That's probably the only time you'll need to go to probation. They'll meet with you in the field in the future, and it sounds like You're going to be one of those low maintenance probationers. Well, soon enough, it can just be a, hey, everything going okay? And you're on the phone with them. Okay.
Sure.
Ms. Simpson?
Good morning. So Mr. Cook, you're going to report to the Clayton office. That address is 1331 Citizens Parkway, Suite 201. And that city is in Morrow. And the office number for that location is area code 770-960-4100. In addition, Mr. Cook, I need to get some further information from you, so I'm going to give you my contact number. I need you to call me as soon as you are released from court.
Yes, ma'am.
My number is 404-783-9218.
Got it.
Thank you. Nothing further, Judge.
Thanks, Ms. Simpson. Ms. Boykin, last question for you, and you're welcome to step down.
Yes, sir. Thank you, Judge.
Good luck with everything.
Thank you.
And remember your younger kids' ages, okay?
That was just emotions.
I understand. Sometimes your office files a motion for null pros. You made a pretty clear record that will be part of this record. And so Ms. Nelson can take care of the null process for the other defendants, but didn't want to do that if you were going to be filing a formal motion.
No, we go on the court handling that.
Okay.
Made a pretty clear record as to these.
You very much did. And I'll make sure Ms. Nelson takes care of that.
Okay.
I told you. You were going to get mad. You were going to get mad. When I saw this was originally an immunity hearing where the prosecution laid forward all the facts, which they did in 2022. And with the new ruling from the Georgia Supreme Court, the judge would have declared, probably, that they did not have the immunity as peace officers. And they could move forward with all the charges. And instead, they all walk. Null pros on the rest of them, and Mr. Cook, who was first in 5 years probation for murder. And you saw it yourself. He only felt sorry for himself. He wanted to move forward. He didn't even apologize to the May family. He couldn't care less. The tears he shed was for himself. Oh no, my life is going to be a bit rough. You should be in prison. And prison for a former jailer, that ain't fun. But that is what happens when you kill a guy. Now, here is what should have happened. Oh, Mr. Jingles. Let's see here. Where is it? There. This is what should have happened. Press release. Former prison guard sentenced to prison for assault on inmate. This is from December 1st, 2025, U.S. Attorney's Office, Northern District of New York. Michael Williams and Rohail Khan joined Brandon Montari in assaulting an inmate at Mid-State Correctional Facility. Syracuse, New York. Michael Williams, age 39, of Bloomingburg, New York, and Rohail Khan, age 28, of Utica, New York, have been sentenced to 21 months and 24 months in federal prison, respectively, for depriving an inmate at Mid-State Correctional Facility of his rights under color of law. Acting United States Attorney Sarkon III, blah, 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 made the announcement. When Williams and Khan pled guilty, they admitted to assaulting an inmate at Mid-State Correctional Facility in April 2023, along with Federal Correction Officer Brandon Montari of East Concord, New York. Montari, Williams, and Khan punched and kicked the inmate without cause in a hallway in the middle of the night, and they later agreed with each other to lie about what happened to internal investigators. After the beating, the inmate was forced to reveal the natures of his underlying criminal conviction to his fellow inmates, and within 24 hours, the inmate was hospitalized after an attack by another inmate. Yeah, this specific inmate was a sex offender. And the prison guards decided, you know what? We will have him tell everybody in prison. Now, do I feel that much sympathy for the fucker? No. But these are the prison guards. They're supposed to be better than the inmates. And now, they are inmates. And for the record, this guy lived. This guy lived. That's the difference here. In that case, out of New York, 3 people went to prison, federal prison. And they didn't even kill a guy. In Georgia, in Fulton County, they killed an inmate. Not even a prisoner. An inmate. Presumed innocent. But because he had an episode in his cell, they decided this guy does not deserve to live, and now they all walk. Whoopsie daisy. Whoopsie fucking daisy. Sometimes this world is fucked when stuff like this happens. People who are paid to keep jail safe and the inmate safe decides to murder. And the justice system says, you 5, out of the courtroom. You probation. A man is dead. And his murderers walk. I wish I could only stream fun cases, but this case is important. Because, again, welcome to fucking Georgia, to Fulton County. Justice does not exist in Fulton County, Georgia. Now, tomorrow it will be a funnier case. Tomorrow it is the Hernandez case. We are returning to the Hernandez case. Last weekend, we went through the opening statements in that trial. Tomorrow, we are going to check some testimony. And, there's going to be snark. There's going to be words. It's going to be snark attack. So tomorrow morning, US time, maybe 8 or 9 a.m., I'm not sure. Depends on me. And then we will spend a few hours with that case. And it's going to be all snark. It is the government stole their babies, the Hernandez trial. Now, folks, the Hernandez family won and got their babies back. So Megan is doing her thing on her channel, Megan Fox. I'm doing my thing on my channel. And so you get two different types of snark with this case, because these fuckers really, really deserve it. The state, the prosecutor, the state's witnesses deserve all the snark we can give. But that is what I had for you today. It is Thursday. It is 10:30 p.m. where I am. I think I'm going to have a beer because tomorrow I have day off. Folks, thank you. Thank you for allowing me to do this. Thank you for hanging in there. From me and Mr. Jingles. You all have a good one. Oh, look at that. Thank you for being a member for 30 months. Yeah, Gigi, my first and best moderator, is a former prison guard. And she says she has zero sympathy for bad guards. Yeah. Folks, see you tomorrow. You all have a good one. And remember, hug your family. Unless your family is shit, then screw them and give your love to the people who deserve it. Bye-bye.